then I'll jump in.
Yeah, so Attorney Bradle did all the working for it, as you can see. I just had to sit there. But representing Kelsey Fitzsimmons, as everybody knows, has been a privilege of ours and an honor. And I think today we saw a new day. We had a new judge. We had a different attitude. We had an approach to what we wanted in this case, which was everybody's entitled to a fair trial. Kelsey Fitzsimmons is innocent until she's proven guilty. We believe she's innocent. And we look forward to, in a very short period of time, bringing this case before the court on the merits. I think we made a lot of progress today. We appreciate that this judge was willing to listen, to try and resolve questions, to resolve problems, not create problems. And so I think on balance, given where we were a while ago, we made a lot of progress today. And we have a lot of work to do, but we will do it, and we look forward to our day in court, as does our client, Kelsey.
Attorney Coakley, when's the last time that Kelsey was able to see her son, and what kind of impact is that having on her in this case?
I'm going to let Attorney Bradle address that.
I mean, Christina, just in a very general sense, you know, it's been a long road. It's been a rough road. You know, we're coming to the end of it, and we have two jobs here: is reunification, number one. And, you know, to address this case number two, you know, we really need to get this thing done so we can focus on family court, and it's coming soon. So we're optimistic, and we're going to do everything we can to get this case heard on the 23rd and get it done.
Are you representing Kelsey in family court as well?
So it's a group effort. Yeah, she's got a great team over there. Julie has his lead counsel in family court, and we're supporting her. And, you know, she's sort of been hamstrung because of these orders from this court, basically saying, you know, thwarting the family court from doing their job. So we expect that to be addressed soon, and we're optimistic, and we're very happy to have Judge Karp on the case, and we think we're going to get a fair shake, and I think he's going to address it very soon. And that's, you know, Kelsey's number one priority.
Kelsey, are you able to talk a little bit about, are you more hopeful with the judge that you saw today? Are you able to comment on that?
Yeah, I am.
Are you able to step up?
I am more hopeful with this judge.
Why is that?
It just seems reasonable and fair the way a judge is supposed to act.
What are you looking forward to with trial
We're all
coming up?
encouraged by that, you know, and Kelsey wants to kind of let us take the wheel today in terms of talking to you guys, but that's something that, you know, we feel has not been present in this case, and it is going forward, and we're going to address things on the merits, and we feel like we're going to be heard. We feel like we're going to get heard by the court, and things are going to be okay.
Obviously, a big part of the hearing today was focusing on that video and what actually happened there. What do you want the court to take into consideration now moving forward?
In terms of what?
In terms of that video, do you think that there should be a conflict of interest ruled by either the court or the district attorney's office?
Yes, we believe there's a conflict of interest and that it can be addressed by the court, but, you know, Judge Karp's got to make his rulings, and we respect his rulings wherever they are, and if it has to go that way, then we'll take another route. But we feel that, you know, we believe that the DA's office here has an interest in propping up that witness, and, you know, the alleged crimes there should be evaluated by an independent prosecutor.
What is their interest in propping him up, as you said? Like, what, you know?
Disclosure from the prosecution. Can you tell us what that disclosure was?
So we're asking for a disclosure. This is a standard request that we want promises, rewards, inducements that have been granted or implicit in any witness's relationship with the prosecution. And it's very standard discovery. We wanted to push the Commonwealth and push the judge to really provide something meaningful, in the sense that we want all the communications surrounding that, if any, and we want something in writing from the Commonwealth about what they're doing with these witnesses that are apparently getting a pass on alleged criminal activity.
And I think because the judge has asked us, and counsel have agreed to do a witness list, we will see who all those witnesses are going to be. And then if we need to move further on any of those questions, we can do that. You heard the judge say he does not want this to be a trial by ambush. It shouldn't be. So both sides should really know what we are going to be arguing about going forward. And that's the work we have to do in the next few days. And the judge, as you see, is going to look at that, reconsider some requests on the bail, on March 12th, which we think is a good sign in terms of getting ready for trial and making sure we're ready. But we feel confident that he understands that both sides deserve a fair trial, and we're looking forward to working with him and moving forward.
Tim, after the sidebar,
You guys wait. How about let's go our left to right, and we'll get everybody. I promise we'll get everybody. Don't worry.
yeah, after the sidebar, it sounded almost like there was some admission that there was an inducement as it related to. Can you explain that a little bit?
Well, I think given the exhibits that we filed and the motion we filed, it's pretty obvious that there's some potential exposure there, to put it politely, and the government is acknowledging that it's implicit in the situation. I think that they're looking the other way, and they need to put something in writing to that effect.
So,
Yeah.
well, didn't they say that they looked at the evidence, they looked at what you submitted, they considered the whole context of the case, and they decided no charges were warranted? Why do you feel like they weren't in a position to make that decision, and why do you feel like they have an interest in propping him up? The prosecutor said he's actually not that important a witness for us.
Well, it's not a question of whether they're important or not. And this is the first we heard of it today. This is the first time that we kind of flushed them out to actually say that they're, we kind of flushed them out today, that they finally said for the first time that, we'll give you the notice that we're not prosecuting him. We don't think it's a criminal case. I think the fact finder will have that ultimate decision in terms of whether or not, there's a behavior that's relevant to their determination.
I did want to ask on the North Andover police officer, you're planning to file a Rule 17 motion to get what do you think there is there?
Good question, Charlie. So we don't know. The way the discovery works is the courts always ask the defense, well, what do you want, counsel? I'm like, I want what the rule says. I don't know what's out there. It's the prosecutor's job to go figure out what's out there. And so we investigate our case. We get bits and pieces of information, and we use that information to point the prosecution to certain relevant evidence, certain specific evidence that we can say to them, go look here, go look there. It's not incumbent on us to know exactly what it is. They have a legal duty to go find it, especially if we say, look in this particular location. So that's all we're doing.
You said today you're on the fence about whether Dr. Zeisel will testify. Does that mean you're on the fence about whether to pursue a mental health defense, or have you made a decision on that?
So everything's still on the table. Everything's up in the air, and everything's still on the table. We don't. I guess it can't be up in the air and on the table. You get what I'm saying?
What are the others?
Kelsey, can you just tell us how difficult it's been to prepare for a trial while not being able to see your son at this point?
I don't want to comment on it.
I mean, as you can imagine, she's pulled in a million different directions here, and we have to get down to business, and that's hard for somebody in her position. And I have immense respect for her perseverance in this case, as all of us do.
So,
Tim, on the motion about the bail, what else are you prioritizing? Obviously, you got the time requirement.
So we just want to get Kelsey some freedom and some access. There's these repetitive conditions that are just incredibly onerous in a case where someone doesn't even face jail time on the other end of it under the sentencing guidelines. So it's a unique situation where I've never had a case where the likely outcome in the sense of a conviction would have been probation, and then that person gets locked up pre-trial is unprecedented in my 30 years. So we want to get her in an appropriate bail situation from a fair judge. That's what we're here for.
and we
Is
should
this
note
too late?
that she's having compliance with all of these conditions, onerous as they are, and I think asking today for the court to reconsider them in light of that, in light of where we are, and his willingness to do so. He said he would entertain other issues that we brought up on March 12th when we come back.
And he's got to get up to speed on it.
The 12th is kind of late. It's like a week out, right?
Well, we'll take what we can get. We have to take what we can get.
Kelsey, are there any misconceptions you'd like to clear up? Anything you'd be comfortable saying?
I don't want her to kind of just start pontificating about a lot of things, but she's been through a lot, and she just wants us to kind of go through it. Mike,
Special prosecutor, the judge seemed like he was going to do anything about it. What can you do about it? Because it looks like this guy did some criminal stuff. I mean, just looking at it, it seems like it.
He's the judge. You know, he's the judge is focused on the notion of separation of powers. The way I see it, you know, I've read many cases where the court decides, they say, hey, this person has a conflict of interest. They reverse convictions. They do all sorts of things. So I don't see how this is any different. You know, but I respect Judge Karp immensely, and you know, he sees it as a separation of powers issue. We're going to have to grapple with it in another way. You know, we could file a request for a clerk's hearing. We may do that. We don't know. We have to think about it and react to, you know, the situation. And we just got that information today, so we'll have to see.
Can we talk a little bit about where does the motion to recuse McCarthy, where does that stand right now?
So it was denied as moved, and Judge Ricciuti, the chief judge of the Superior Court, he took it over and he made that ruling, and he took Judge McCarthy out of the case. And as far as we're concerned, that means that Judge Karp is the judge. You know, we can't have it halfway where he doesn't want to make any rulings and defer to a judge that's not considered the case. So
how confident are you that he's going to rule that Judge Karp will be overseeing this whole case in its entirety?
I think very confident. I think that makes sense. I don't think
Judge
that.
Karp said he was going to ask him,
Yes.
and he felt confident that that was good. It makes sense to have the same judge now make all the decisions that are applicable to trial, for the trial, including whatever their situation is. And so we're hopeful that, as Judge Karp noted, he will be in charge of this case going forward. Whatever comes up.
Can I ask one more question? I was surprised to hear that this whole time Kelsey's been able to drive. I know that you spoke about her being apprehensive, having trauma after being, you know, incarcerated after that last bail hearing. Is this something that you either overlooked or you were just out of an abundance of caution she wasn't transporting herself? Because, you know, it seems like it came out of this discussion today that she's been able to do it all along, or at least Judge Karp's interpretation of the order is that she could be doing this.
So there were all sorts of verbal pronouncements from the prior judge, and you know, given what happened to Kelsey, we have to be extremely careful. And you know, there were all sorts of verbal restrictions that apparently didn't get into the contract, but we were certainly in no position to take any liberties with everything she said, especially given her inclination to put Kelsey in jail. So we had to go with everything verbal that was put out there as well, and that was definitely put out there.
So Judge Karp said, "Good to see you again." What's your experience arguing about that?
Judge Karp, I haven't seen Judge Karp in probably over a decade, and you know, Judge Karp's been a very respected jurist for I think about a decade, and probably 25 years ago, we were both in the Suffolk DA's office. Different reasons.
I did want to.
Tim.
So good question, Jessica. So we got the surveillance system back today from the House, and so now, you know, it's been gone through with a prosecutor's eye, and now we get to go through it with a defense eye. So to be determined. Stay tuned on that one.
Hey, Tim, we learned today for the first time that the Commonwealth decided, hey, we're not going to prosecute based on what you advised them of back in August.
Yes.
Have the federal authorities been informed of potential issues, bank fraud, wire fraud, anything like that?
So one of the predicates for pursuing that is that you have to file a complaint with, it's an FBI-sponsored agency, and we're going to look at that, and we're going to talk to Kelsey about that as well. So that may be an avenue as well.
What if you did go before the clerk magistrate and they go forward with the DA's office now prosecuting?
Well, Mike, wouldn't that put them in an awkward position? So if the clerk magistrate finds probable cause and issues complaints, then I think it would be something that would put their feet to the fire about whether they prosecute it or whether they pass it along to an independent prosecutor. So let's see what happens.
Or to another county. They have the option of going to another DA's office as well.
Can I ask Kelsey how you feel about some new freedom? It's bittersweet. It's only to Tim's office, but you're able to leave your home. You're able to drive. How does that feel knowing that you have that freedom today?
I think it's a step in the right direction. We're only a few weeks away from trial, definitely the hardest thing I've ever gone through in my life, and we're just gonna keep standing strong and make it to trial.
Thanks,
Everybody good?
I saw Hank Brennan in the elevator today when you mentioned any interest, special prosecutor.
I would love for Hank to get his hands on this, and
I don't think he was
somebody
here for that.
will take anybody. But I think he had some other business today. He's still a defense lawyer as well.
Thank you all.